Good morning, everyone. Hey, everyone. Good morning. Welcome to the SIBEN webinar series. My name is Alexandra Ndara. I work with InfoDev's Climate Technology Program. The program works with local counterparts in developing countries so they proactively and profitably adapt, develop, and deploy policies on smart technology and products on smart technology and business models. We're working so far with 7 locations. These are Kenya, South Africa, Ethiopia, Ghana, Vietnam, Morocco, and we have also a Climate Innovation Center in the Caribbean. Right now we're working towards establishing a few new ones. Among them, we have Egypt and Nigeria. So we have developed, as an InfoDev Climate Business Innovation Network, we've developed this series of webinars so our CACs, Climate Innovation Centers, can actually learn from each other on different challenges that they face. Today our presenters are going to talk about intellectual property and how to protect climate tech products. And I'm going to pass to let Angelo talk. He will be our moderator for today's session. He's been working with Nigeria and the Caribbean, both Climate Innovation Centers, on their design strategy during the design phases of the CIC. So, Angelo, please go ahead.
Thanks, Alexandra. Is my audio working? Can everybody hear me? Let's enable some audio for folks. I haven't gotten a response. I can hear you, Alexandra, but I can't hear anybody else. Thanks, Michael. I appreciate that, and thanks, Anvar. Great. Thanks everybody for joining. I see quite a few of you are in attendance today, which is great and a testament to the relevance of this topic to the work that we do in CICs. We have Magnus and Carrie-Ann with us here from House of Knowledge. They've graciously offered to lead a discussion around IP and patent protection and the other questions related to those topics today as they pertain to CICs and our founders that we're working with. It's a topic that came up repeatedly at recent CIC meetings as important to us, important to our founders, so we're happy to have a discussion here and learn a little bit about it through an overview, get some examples from one of our CICs, and then take questions and have a great discussion. So, without further ado, I'd like to turn it over to our colleagues at House of Knowledge.
Thank you, Angelo. So welcome to this webinar on how to protect your inventions and innovations, or as we would say it a bit easier, how to stop being copied, and if something happens, somebody copying you, how to deal with it. Before we start, I'm just going to give a short introduction on what IP is.
Magnus, can you give us a second? You're coming in and out for me just a little bit. I want to make sure.
Yeah, we have a backup plan.
Let's pause for a second. Magnus, I'm using audio. Came in and out a little bit. Is anybody else having that same problem, or is it just me?
It seems like it was my computer. We have a backup computer. Sorry. So we're on backup solutions, so backtracking. So my name is Magnus. So we're on backup solutions. So getting back to the presentation on how to protect your inventions and innovations. So putting it a bit easier, getting back, if somebody copies you, what to do and how to prevent others from copying your great projects. And before we start, we'd like to say, what is IP? Well, IP, or intellectual property, is the knowledge of your firm, your solutions, and your ideas, or your know-how projects. I think that would be a... Before we start, we'd like to say, what is IP? Well, P or
There was a little bit of echo there, but I think
is the knowledge of your firm, your solutions, and your ideas, or your know-how. I think that
there was a bit of echo there for a moment, but I think it's cleared up. Yes, I think we're good to go. Thanks for the introduction.
No, it was not.
You sound fine. I think there may have been two mics on at once there for a moment. So let's continue. But I may, if anybody has an audio issue, please just put that in the chat window, and we'll try to respond as quickly as possible.
Okay, we just changed
Thanks.
the computer here. My computer actually crashed. So then let's take 3. So you have a backup computer. And you have a insane echo.
So let's continue, but I may.
So then let's take 3. So you have a backup computer. I think everybody. So you have a backup computer. Is everything okay then?
Everything is great right now. Yes, thanks.
Okay, so let's backtrack once again. So let's this time hope that the gods of the computers are with us. So my name is Magnus, and I have with me my colleague.
I'm Kay.
And then backtracking to the presentation. So today we're going to have a brief introduction to how to protect your inventions and how to protect your innovations. Or said a bit easier, how to prevent others from copying your brilliant ideas and what to do if somebody copies you. So what is really intellectual property or IP? IP or intellectual property would be your knowledge, your know-how, it could be your ideas or a specific solution which may be protected. And let's see, do the slides follow now? No. Seems like there's some bugs with the presentation as well.
I can see the title page now.
Yes. So then we have the second page. That's good. So okay. So nobody, I thought everybody saw that. I apologize for that. So now the computer gods are with us, and we do take 5. Magic. Okay. Yeah.
Okay, so today's topic is intellectual property rights. You will, during this hour or so, learn that this is quite interesting topic and very useful to know when you're developing your idea or your business. So today we're going to look at the different ways to protect your idea. We're going to look at the legal framework, and then we're going to look at the more informal ways to protect intellectual property.
It works magic. So, how can we protect our solutions or ideas or know-how legally? Well, we got patents. And patents is a tool which protects a solution in the market. You apply for the protection for up to 20 years. So, if, for example, if you apply for a protection or a patent in Ethiopia, you're only protected in Ethiopia, not the neighboring countries. You will then be able to protect a product, and this product might be, for example, a stove, a new way of a more energy efficient stove, or it could be the way you produce this stove, or it could be, for example, the way you use this stove. Let's say you want to send a balloon up in the air and use this stove in order to heat the air. That would be an application on how you use this stove. What people tend to forget all over the world is, why do we really have a patent system? Well, the patent system's purpose is, well, it's actually 2 purposes. One of the purposes is to be able to build on others' inventions and innovations and then bring innovation faster forwards. The other part is to actually gather knowledge. So the patent system is actually the largest library in the entire world. The problem is that nobody actually uses this as a library to look for information to learn from. That is the essential part. And as I mentioned in the beginning regarding patents, it needs to be new.
Another way to protect the product is through design. As Magnus mentioned, the stove, design can protect the visual look of a stove. It refers to how it looks and not how it functions. It's the same protection. You have to apply each country, and it's valid for 25 years. And you also have trademark. Trademark is something that identifies your company, either through the company name or a logo or slogan. This can be protected through a registration of trademark. Most countries have this system in place, and it's fairly cost-effective and easy way of doing it, of registering. If that is not an option, where you are, another tool will be through communication and building a brand.
Seems like there's some of you having still some issues connected to sound. Is there a lot of the people that should just take a minute break so you have everybody on board? Or what's happening, Angelo?
You sound crystal clear to me. It sounds great. So I've just asked Mohammed if his issue is resolved now as well. Sounds like Alexandra has a good audio too. So I'd say let's continue. Thanks, Michael.
Excellent.
Working for you too. So hopefully it's fixed for Mohammed, but I think everyone right now is hearing you loud and clear. So thanks.
Excellent. So what we just mentioned is something called patent, registered design, or registered trademarks. Those are formal rights where you need to apply the government for a document to then document that you have this right, and it actually costs a lot of money and it takes a lot of time. Well, you have another legal right or a tool which is quite useful, and it's a bit different. The moment you make something which will like protect the copyright, you protect it globally and for up to 70 years from the moment you die, actually. So you're then people inheriting you, the firms will be able to own this and protect it. But this doesn't go and protect the solutions, but this actually would protect the user manual, for example, of your stove. So this is something that protects art pieces or software codes, but not actually the solutions you're looking for. So this is a bit difficult way or mean to use to protect yourself. What is maybe a bit more what I would say would be quite useful if you have innovation with these more improvements or just made existing solutions a bit better. It might be something called utility model. And a utility model, well, that is it's a little brother of a patent. It has less demands. It seems like the slide disappeared. As well, the patent has less demands, this utility model, sorry, and it's much easier to apply for, and the cost is, well, it's much lower. The problem is that you only get protection in the country you apply, so if you apply for protection in Ethiopia, well, you're only protected in Ethiopia, and you can't move this protection to protect you if you want to sell the products to the neighboring countries or actually worldwide. The third thing that might be interesting as well would be something called Geographical Indications. And this actually protects the knowledge of your cultural inheritance. So if you made the world best stove based on the culture of your country, where your generations have made a better and better stove in order to cook food, well, then this would be a tool in order to protect the name of this product worldwide. So in order to use this name, the product needs to be produced in your region of your country, and nobody else allowed to use this name anywhere in the world. For example, you have probably heard of champagne. It's a drink, and this is only produced in one region of France, and it's only produced in this area. The last tool, which is probably one of the more important ones anywhere in the world, would be actually contracts. Not only the legal part, but also the part where you clarify what we really have been talking about. seems like my presentation jumped a bit back, so I'll try to make it jump back to where it was. It's interesting when there's something within this presentation making it jump back and forth. So that would be the legal tools, or what we would call intellectual property rights. Those are legal tools that protect intellectual property, creations of the mind. And given the different, the legislation of your country and how the legal system actually works, the protection really depends on how you could take this to court. And that is an essential part. Some of you might even get letters from foreign companies stating that, you're violating their patents. And you might find patents or information when you look for it that you feel might be a problem. Well, in my next slide, I'll show you something that's a bit interesting. This is a patent for the United States, and somebody thinks that if they find a patent, it's also valid in their own country. As you see on this patent, it's a patent for the United States, and it does not affect anything sold in Ethiopia or anywhere else in the world. It only regulates things sold in the US. Another thing you could see is that in the upper right corner of the patent, it says it's from 2002. This is a problem with the patent system, that you will find patents which really shouldn't be valid. This is a patent for a swing. It's a tool for kids to play on. And I'm 40 years old, and I know this as existing before I was born. So this really doesn't fulfill one of the major criteria as being new. There's a lot of those patents in the system as well, so even though there might be a patent, it really doesn't mean that it's valid in your country. I will change the slide. Let's see what happens. Yes, we changed. Magic. It works. I'm really impressed.
Okay, we have touched upon the different legal forms of protection of IP. Now we're going to move on to the informal means. It's important to note that these are by no means second best. And in some cases, they are even better than the legal protection. We're going to touch upon that a bit later. And it's also important to note that this is not a question of either or. You should do, maybe not both, but at least you should do this informal IP protection that we're going to go through now. The first one is that you should always be aware of what kind of information you can and cannot share with outsiders. You will have information that is business sensitive, that if it falls into the wrong hands, it can seriously damage your company. So make sure that everyone within the company knows what kind of information they can freely share and what they should not share. When you are dealing with the externals and you need to share information, because sometimes you really do, you need to speak to experts, or you need to collaborate with someone, you need to share information, and that is okay as long as you know what you can share, and not least how you share information. With externals, you use a non-disclosure agreement, or an NDA. This is a way to formalize what you are sharing and what kind of obligation both parties, both the receiving and the giving party is obligated to do, is to keep the information confidential. With employees, it's just as important, because everyone within your company needs to know what they can talk about. And most people don't do this to harm the company. They might do it because they simply don't know. So making your employees aware of what is business sensitive information is a way to protect your IP, and it's a very effective way. As it's routines and procedures to implement in your company to make sure that everyone is aware at all time what they can share. Thinking of, for example, if you have sales representatives, do they know what they can share with their clients or their partners? Do they know what they can show in a presentation? Always make sure that everyone is on board. Brand and reputation is one of your company's most important IP assets. It is the feelings and the association your customers have to your company. and everything you do will build up on that reputation, either it's negative or positive. So when you answer, or you or your employees answer an email, that is a way of building a brand. Your customer service, everything, how you speak about your employer or your firm in a social setting, everything. So make sure that everyone knows how to behave,
yeah,
or talk about, what you call it,
treat the information.
Yeah.
So then the last bullet is, how can you use a business model in order to protect your innovations? Well, if you have specific knowledge on how to make, let's say, a way of measuring the degree of your fertile soil in order to grow a specific kind of plant, and you embed this information into a measuring device you developed. And let's say you can't have a patent on this measuring device, and if you start selling it, everybody could copy it, and there's nothing you could do to stop them. Well, if you look into your business model and say, what do your clients really need? Well, your clients don't need this machine or this measuring device. They need to know the measurement, meaning what would be the soil level. So instead of selling the machine, you could use the machine yourself. You control the knowledge embedded in the machine, and then you give them the information that they need, or your clients need, by the use of, well, this machine you just developed. That is a much powerful way of protecting the way your innovations are conceived, but also what is embedded of knowledge within this machine. There's a lot of funny stuff happening in the background on the technical stuff, so I just hope everything is working and everybody could hear us while we move on to the next slide.
Yeah, we're going to talk about IP versus IPR. How do you manage your IP wisely? As we looked at before, we have options. We can do the formal, the legal way, or we can do the informal way. We're going to take you through some of the decisions that you will be facing.
So just to recap, what is intellectual property IP? Well, intellectual property or IP, that is the knowledge of your firm, your know-how on how to solve a specific problem, could be a solution. Whilst the IPR would be protected intellectual property by applicable laws, or for example by using a patent or a utility model. That would be the IPR.
So when you consider your options, you should always consider the legal framework within the market you're operating within. In some places you have, or countries you have an inexperienced legal system. As is the case for us in Norway, we would never use the legal system in Norway if we had an IP issue, because we don't know what the outcome would be. So always consider the legal system and consult legal aid when you're considering applying for legal protection. If there is no, if that IPR is not a thing in your market, you should consider your options, and the options would be the ones we talked about during the informal tools. For example, keep your cards close at hand. Don't share. That would be alternative to patent protection or design.
Or for example, just using a business model, not selling the product but selling a service. What also is essential while considering if you want to legally protect your IP or protect it with informal things would be the competitors or the competition in your market. If your products are competing with only locals and there are no international competition at all, then maybe not the patent wouldn't be the tool for you. I would say that the utility model would be good because it's much cheaper and it's much easier to enforce.
And also a budget is an important thing to consider. IPR is costly. It costs money to apply and it costs money to maintain protection. So if you do not have the financial means to maintain or protect your IPR, you should consider other options. Sorry. If you have international ambitions, IPR is something that you will have to consider. Even if you don't find it an issue worth focusing on, others will. In the US, for example, in Europe, IPR is something that is a big thing, and they will police it, and they will enforce it, and it might be painful.
Well, we have just gone through, and just so you can see them again. So now we've just gone through the introduction to the tools, and we'll repeat them again. Before we move on, we will enter and explain a case from Ethiopia, which we really think is brilliant. They've really done, as we see it, everything completely correct. I couldn't have kind of advised them to do differently. So I'll show you the case. This is the company Google Energy Saving Stoves, and they're developing on basis of this founder of this company that developed some fuel-saving cooking stoves and some briquettes. And those briquettes are actually what would be burning within the oven. And they figured out what should be the substance within these briquettes and a machine to make this in order to make them dry and really burn well. And really save energy and then stop deforestation and other elements. So this is a really interesting case. And in order to go through the case, they looked at it and they saw that, well, there's something when they started sorting out the information we shouldn't share, and that would be the recipe for the briquettes themselves, the part that's burning. They got a machine making these briquettes, which is quite interesting. Which they have actually protected by a utility model. And then they have the stove itself, which is much more efficient than the existing stoves in the market they are operating within. And in order to protect this product, which you see, this will be really easily copied by our competitors, they really stamp their logos and a name into every stove that they sell in order to get attention from all the clients and establish some sort of trust and relations to all their clients, really making them visible. I think that is really brilliant. I will show you the next slide on this case as well. So there you can see some of the burning briquettes. What they've done is they made a process to use within their machine to make these briquettes, which could be replicated. And when it can be replicated, they can actually apply for patents. But given the way they could enforce their product, they figured out that it would be good to use this utility model. It's a much faster way to get legal protection. It's much easier to get support to do it. And it's something that costs them less. And then there's a question. Give me a second. So, give me a second and I read it once more. So, when to start looking for legal advice? When should you ask the incubator leaders, or when should the incubator leaders be asked for advice regarding IP? Well, I would say the moment you kind of found the idea, you have an idea for a solution. At that moment, you should start thinking, who owns this? Because you might be influenced by somebody else. So please then, at that moment, seek support in order to clarify who really owns this project. And then I would say, is this something that is done by others? If not, you could look into patent databases, others, to figure out how to find more information about it. And then you could sort of sort out what would be the unique features of this project. When you know what will be the unique features of this project, you will also know what kind of legal support to ask for. For example, for this case study, they figured out that they had to sell the stoves. It's easily to copy it, but they cannot protect it or deny others copying. But what they can deny others copying is the name and the logo. And people buying this product know this is a brilliant product. So people don't only buy the stove, but buy their stoves because it's branded with their name and they, with the support of the government or the way it actually works where they are, they know that they can enforce these rights, which gives them some sort of additional protection. Just change line to the next one, bringing it back into something, because we're providing you with a supporting tool which Karianne will introduce.
Well, as part of this webinar, we have prepared 2 different kinds of survival kits for you. One is for the incubators, the advisors there, so how to advise their clients in IP matters, and one for the entrepreneurs on how to manage your IP. These 2 kits will touch upon everything that we discussed here today and go in a bit more in detail. This is it has been a lot of information in a very short time here. So through this survival kit, you will have time to study it in a bit more in depth at your own time. And we are also be available for the incubators if they do have any questions in IP matters. We are here and happy to have a Skype with them for an hour.
So feel free to contact us, ask for some support, and we'll provide you some aid in order to make sure that what we present in this presentation make it more, well, let's say, applicable for your cases. We could set up a Skype, we could support you, have a dialogue with you on how to support you and how to use this kit. But it would be good if you then had a look in this survival guide first for the incubators, and then we made one specifically for the businesses themselves to read through. We hope that will be providing some additional support in order to make yourself or put yourself in a better position.
Is there a question? Oh, sorry, I thought you raised your hand. I'm sorry.
Moving into what we think would be relevant before we do the complete Q&A part. So I'm part of when I presented this case on behalf of Tehut, who's head of the CIC in Ethiopia. I also partly mentioned why I think this is really brilliant and what we can learn from this. Well, what we can learn from is that, and then following up the question Alexandra put on the screen here, is when to seek support. Well, they have been seeking support from the moment they had this idea, and they have differentiated information into information that never should be shared with anybody, meaning this is the recipe which is in the head of the owner of the firm. That is a business critical information that is kept confidential. Then he made a machine with employees, and in order to protect this and then also establish trust within inside the company, they apply for a utility model in order to protect it when hitting the markets, in case somebody leaks some information willingly or unwillingly. The other part will be that when you want to sell something you know you cannot legally protect, and you need to sell it to a large consumer market, the best tool and the really best tool would be the logo and the name of your firm. The second best part would be how you manage your reputation. If you always provide a high quality product, people will associate high quality product with the name and the logo of your products. This would be the drivers of the sales of your products. So even though others could sell similar product a bit cheaper, they might even choose your product because it's less flaws with it. And that's why we think this is a really, really good example. But I already went through this since we had to intervene and also do this in combination. So I think in order to save time, we'll just move over to the Q&A part, where we will go into questions we have picked up from the different participants in advance of this. So the first one would be, there's no access to legal registration, then what?
That is a question that we often get. There can be many reasons why there is no access to legal registration. It could be the lack of funds, or it could be that the system is not in place. Then we have the informal tools to protect your IP, as we discussed a bit earlier here. It's first of all, know the information that is sensitive to you and that you need to protect. Work on developing a loyal relationship with your client through your brand. You have other?
No, I think that would be enough. But again, the most important tools, regardless of where you are in the world, to answer the first question would be differentiate information. What information you never share, what information you share in confidence and you protect by applying for a patent or utility model. That is actually a publication, so it's really good to know. Everybody knows what you do. And then the information or the part of the product you could distribute into the open market, and then you control it, for example, by the use of putting your logo on it or just actually making better products. Then how to protect your idea or products when you have limited resources? I would say it's the same answer. Differentiate the information. This is actually the biggest problem for the largest corporations in the world. If they're Apple or they are the windmill producers within Denmark, it's the same thing.
And make sure that everyone in the company is on board and knows how to treat confidential information. It doesn't help if you and your manager team knows what to do if your employees are sharing information they should not be sharing.
Before I move on to the other questions, are there any questions from you who are then listening into this webinar that we should answer in advance, or should I just continue on answering?
Thank you for that break. Folks, please enter questions in the chat window and we'll respond to them as they come. I have one question that I'd like to start off with to add to your list. I think all of them on the list would be great to go through and get your perspective. But one that comes to mind is the flip side of this, and you mentioned that this is a library, and is there what is your advice on in the early stages? An entrepreneur might find themselves in wondering if somebody else has already patented or received some kind of protection for a competitive device or service.
Well, in order to answer that, I kind of, let's say you're in an area where you don't have a functioning patent office at all. I will go to the European Patent Office. We will provide you the links afterwards, and Alexander will provide that with the emails, with the documents. So all the guys you mentioned will be sent email to you. It will be a SPASnet, and then you could search for any patents anywhere in the world, which is then published, and you can look into it, and then you can learn from it. If you're in an area where you have access to your own governmental patent office, I would advise you to actually seek them and ask them for support to search for you and with you, because then you would know how to and really evaluate the information you kind of get. I would advise to do this when you are evaluating your projects, because then you could get a lot of inputs, and you know what not to use time on if there's a lot of patents on it or utility models within your country that you could prohibit you from doing this. And especially if you figure out that your project has a global potential, that is when you really need to consider patents. Not necessarily to protect yourself, but others' patents might stop you on the borders with their customs, which Karianne was working on in Norway, actually being charged with IPR in the customs. I could read up the next question on the screen here, just so everybody get it. Then we'll figure out who will answer it, depending on the topic. So, what advice do you have for the reverse situation? Entrepreneurs that are concerned they will be forced to license a foreign technology or shut down due to multinational claiming copying. For example, mini-grid developer in Morocco that is concerned a global company will claim infringement of a controller or a piece of software. They may not have the resource to defend themselves against the claim. That is a very, very good question. How do you protect yourself against the corporate large, predators, which then try to scare you off? This is why I added this stupid patent on the swing. First of all, you go and, since you're in Morocco, I would go to your national patent office. I will ask for support to look up this patent, because you can actually search this patent and you can look at it. And then with the support of people working in the patent office, they could look at your project and compare to their patents. And if they say, or they make a written statement to you, say, this is completely different from your solution, well, then you can walk away as an happy person and say, this is irrelevant. You got a third-party statement stating that this is irrelevant. But it's really important that you have this third-party statement. It's not your problem. Because then it's not your less skilled opinion, but it's actually done by the experts, and then it's less liability. If it's software, I would say that most likely the software would not be protected in Morocco. It's mainly in the US you actually get patent protection for software. It should not be possible to protect software at all. It's a contradiction to the purpose of the system and what it actually should protect. But there are loopholes. And you mentioned that it's software with a piece of hardware, and then that is actually the loophole. So you would have to ask for advice from your local patent office. If there's no advice to get, there is an opportunity to address WIPO. It's the World Intellectual Property Office that might be able to give some advice. Or you could use the time which we will then offer to support. We can have a look at your project and ask somebody to have a look at it and see how we could aid in this specific matter. But first of all, check if the patent is valid in the region you are. If this is, say, for example, a patent which is applied for in Egypt, it doesn't affect you when you work in Morocco. And make sure that they actually pay their fees, because if they didn't pay their fees, it's not a valid patent. And the best thing, if you, and this is kind of the candy, if you could find newspaper publications anywhere in the world, and you figure out that this has been published before or prior to this patent being applied for anywhere in the world, you could pick up this piece of newspaper, show it to the patent office, and they will terminate the patent. So that's why it's so essential. That's why me and Karianne stressed all the time, differentiate and sort your information. That is where your goal is. You know what is published. And when you know what's published, you know how to terminate others' patents. That is a really good way of protecting yourself from others' patents. Any other questions? Or should I continue on reading up a question which we could answer from the list we got in advance?
Great question, Michael. Yes, thanks. Please go back to the list, and we'll continue to add more in the chat window. Folks, feel free to contribute. Thanks.
So I would read up the next question, which Karianne will answer. How much to share so you promote? So to promote and then still protect your project or idea?
I think you missed one.
Oh, sorry.
How to protect your idea and land an agreement when you meet with an investor.
Oh, sorry. Yeah, okay, then. Sorry.
Very important, I think.
Yeah, we're on the same page here.
Okay, so this is an example or a situation where you need to share. We spoke about this a bit earlier. Sometimes you need to share information even though it's scary. This is an example where you actually have to, because no one is going to invest in something they don't know what is. But the important thing is to firstly use an NDA and not tell the whole story. Don't reveal everything. Don't make it easy for them to grab your idea and run and make their own company out of it. And then it's important to show the investor that you are aware of your advantages, you are aware of what your IP is, you are aware of what sets you apart from your competitors, and show to means that you have done to protect these. Such as you always use an NDA, you have employee contracts with all your employees, you have routines to safeguard confidential information. There's a whole section on this in the survival kit, so you can read more about it then, but that's the fundamentals.
So, as Karianne said, you need to differentiate what they really need to know. And as you could see from the chat, I answered from a follow-up question from Alexandra. Does it only have to be newspaper? No, it's any kind of information. It could be a web page, a technical leaflet, it could be the user manual, actually. So if you publish your user manual, you could actually have terminated somebody else's patent because it's published. If you presented something in a meeting and you can document it's actually been published in this meeting, it's a video recording. I talked in a large crowd, or I've been at let's say, a gathering of entrepreneurs, and let's say a few hundred people there, and everybody could state on their honor that this has been published or been talked about in this meeting. That is enough documentation to terminate a patent. But also make sure that this kind of information could terminate your patent, so it kind of goes both ways. Is there any more questions to follow up? From those, I think there's being written a new one. I could then, while that's being written, I could read a new one. How to make sure that there is no patents on your products? Well, it's not that difficult. I would say you need to look into the patent databases. You can, for example, go to the European Patent Office or your national patent office, and you just search, you enter search for a patent, and you just enter keywords. Let's say you're making cooking stove for making food. You just write cooking stove and food, and then you probably get 200 to 300 patents. Read them all. That is a good input, and then you know if somebody patented. If you don't find anything, you didn't search properly, or you probably had a spelling error. You will always find at least 10 patents. But if you have narrowed down your search to, let's say, 50, there is no point of searching thoroughly. You need actually to look through all of the patents. And what is essential to know is that what is protected is what's described in the claims. No more questions from the audience?
Well, I would ask, and thank you for adding to, that was the question I first asked. I do wonder, you mentioned going to the EU Patent Office. In the past, I've used Google's Advanced Patent Search. Do you recommend that tool, or do you think it's less effective as going directly to the EU website?
Well, I would say it depends. If you've been working in a large European corporation, that would not be allowed to use at all. Then you will actually fill in information somebody can read, because somebody is actually doing industrial espionage, eavesdropping on the line. So I would advise against using it if you are searching on your own projects. If you're loosely looking for information regarding a cooking stove, it's brilliant. Or if you're looking for others' patents. But if you're looking for the specific solution you made yourself, don't use Google Patent Search. It will be the same as you use Google Translate. All your searches are indexed and they are made available. And that's actually made a major security issue in Norway, where the Ministry of Defense have used Google Translate to translate stuff, so governmental secrets were then online. So for the same reason, do not use Google patent search. Only for searching for information to build on, and then use WIPO search pages, use your national search pages, or any country, if your patent office doesn't provide these services, which will speak a similar language as you use in your country.
Thank you. Let's go back to the list. So I see Mohammed is typing, but let's go back to the list. And let's also, I'd like to leave a few minutes at the end just to learn a little bit more about House of Knowledge and learn a little bit more about when to get in touch with you for support.
Yeah.
So let's just save a little time for that. But let's go to the next.
Okay, that's very good. The question was answered before I finished typing, so that's good. I'm going to read up one more question Mr. Kariani is answering, which is the last question, and then we could kind of finish. Local versus international IP legal advice, because those are completely different.
Well, IPR legislation is different in every country, and although you have certain experts that knows other local laws, it's always important to contact a local legal professional to make sure that you get the correct advice. If you don't, you might have consequences. So always make sure that you seek advice in the market you are entering. Do you want to add something to that?
No, I think that is good. We have. Then I just give the word back to you, Angelo.
I think there is one question we missed, and that's what if you've been copied?
Oh yeah, that is one important question we missed, and that is, what if somebody has copied your product? Then what? And let's say you don't have a legal protection at all. So there is no patents, there's no trademark, no nothing. Legally, there's nothing you can do. But what you can do is, if you can document that you make a better product, he will still start buying from you, and then you could then start marketing your products, and then you can kind of outcompete them afterwards. So it's kind of your response would be, I will brand all my products. I will go out there being proud of my products and saying my products are better, and people will start buying them. Depending on the legal status of the region or country you're in, there are marketing laws. So even though you don't have any patents or trademarks or anything, but somebody is actually directly copied your products. You have actually in some countries protection from the marketing law that those copying your products are confusing the customer by stating this is your product, which is not. And then you have kind of indirectly protection of your solutions the other way, by how the legal system protects the users. But if you have legal protection, for example, you have a utility model, you need to have the money to take them to court. If the same goes for patents. But in some regions, there's a lot of people popping up, making new copies, and when you then finish suing them, they go bankrupt. And the next one goes bankrupt, and the next one goes bankrupt, and at the end you actually go bankrupt yourself because you use a lot of money suing people. Then don't start suing them, outcompete them by making better products, because there's no point of fighting windmills. Yes. So that would be the last essential one, and we could follow up this seminar with new seminars, so that would be the next slide, but I'll give the word back to you, Angelo.
Can I add something before you finish with this this question? It's difficult when you're being copied. It's difficult to do something about it because the product is already out there. But you can learn from it. Make it harder for them to copy you the next time. Be careful what you share of information and who you share with, and do something that makes it hard to copy. make some traits do something that distinguishes you from the competitors that they are not able to copy.
Giving the word back to you, Angelo.
Thank you. So I'll say this has been helpful for me, and by the activity, I'd say helpful for all of us. There are a few things that I'm really taking away, such as really being thoughtful about what differentiates the offering, being thoughtful about the marketing side, thinking about brand and claims that can be made and trademarked, and equally as much as on a utility side, I think is very insightful for our entrepreneurs. Talking with the employees about what they can share and can't share, just so that they're all aware that patent protection is not just one person's job, but it's everyone's job in the company. I think that's very insightful for us. So thank you. And I do think these follow-ups all have merit. So I'll say to the folks on the call to look at this list and suggest to Alexandra if there are particular ones that you are interested in, and we can schedule those for subsequent webinars. But with our last couple minutes, I would like to learn a little bit more about House of Knowledge. Can you tell us a little bit more about how we might continue to engage with you beyond webinars? What is it that we should look to you for support with?
Well, what I can just tell what House of Knowledge is that we are a consultancy firm, and we do consultancy worldwide, from startups to Fortune 500 companies, meaning the largest firms in the world, and then on how they could protect their competitiveness, what's really unique by them. So we're not how to make patents, but how to be best potentially protected. And we do a lot of training with firms, and we do a lot of strategic advising and helping people building up infrastructure. And in order to support ourselves and aid ourselves in doing this kind of services, we made e-learning, which is potential there. We made these guidelines, which we have will provide for you after this session. And we actually made some serious games, which are games which are more simulations in order to train you to do really hardcore business development with IP, which is the core of what we really do. And as I said, we have offered to any of those incubator leaders, if there's some kind of support you need, you could just address them, and we will provide at least 1 hour for free to aid you in your needs.
That's very kind. Thank you. I see Michael might have a final comment here, and Alexandra, can I turn you over to you to close?
Kay and Magnus,
so Michael,
for their wonderful presentation, and I just want to echo what Michael said. It is great to have.
Thank you. Yeah, so mirroring my statements of thank you for the
the knowledge and the experience
Alexandra?
and tools you have to different environments and to different not just regions but also products and sectors. So it will be good to continue this conversation, and we will talk again, as Angel said, on potential follow-ups on the topics that you have suggested. Thank you so much.
Thank you so much for your time.